Almost a year ago today, the United States Court of Appeals for the Fourth Circuit heard an oral argument in a quote-unquote assault weapon case out of Maryland called Bianchi. And yet here we are almost a year later, and we don't have a decision. Do we know what's going on? Well, a lot of people have been asking me this, both on this channel and on X at 4Boxes Diner, and I think I may have an answer for you, and you're not going to like it. It's going to be anti-gunners playing games with their gun control laws. Stay tuned. Let's break it down. Let me tell you my theory when we get back. Hey folks, I'm Mark Smith, host of the 4Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so I think I have figured out something. Now, I don't have any inside information here. I can't be certain, but there's a mystery going on with the Second Amendment involving the quote-unquote assault weapon ban case arising out of the state of Maryland, dealing with bans on semi-automatic firearms and the like, in the case known as Bianchi. It was heard by oral argument in December, specifically December 6, 2022, by a three-judge panel. A panel that seemed to be very friendly to the Second Amendment. At least two of the judges were. One judge, not so much. But it seemed to me, I listened to the argument in December, that we were going to win that panel. And yet here we are almost a year later, and no decision has been forthcoming. What happened? How is it that the three-judge panel applying what should be a very easy in-common use test, because as you know, when you're dealing with an arms ban case, which is a ban on semi-automatic firearms, semi-automatic rifles, magazines that hold more than 10 rounds, these are arms ban cases. You simply have to ask, has the government demonstrated that these weapons, these arms, are not in common use? Because if they can't show they're not in common use, then the government cannot establish that these are dangerous and unusual weapons, because these weapons are obviously in common use. There's tens of millions of them, if not hundreds of millions of them. So they're clearly in common use by Americans. So this should be a very easy case. The other interesting thing is we know that the United States Court of Appeals for the Fourth Circuit has issued a series of Second Amendment related cases since December 2022 in cases that were argued after December 6th of 2022. So how is it possible that in some gun control Second Amendment related cases that had oral arguments after December 6, 2022 and have already been decided with published opinions, and yet somehow the Bianchi case has not been decided, has not been released? Well, because a lot of people asked me about this, I decided that I would take a look a little bit more seriously as the time has been ticking. And I think I figured out what's going on here. I think that the Fourth Circuit Court of Appeals is playing games. And remember, as a reminder, the United States Court of Appeals for the Fourth Circuit is, generally speaking, terrible on Second Amendment issues. There are some judges there that respect the text of the Second Amendment and will apply faithfully and honestly. And the Fourth Circuit is not the worst court of appeals in America on Second Amendment rights. I think that's probably the First Circuit Court of Appeals out of Boston, of which there's no combination of three judges that I think you could actually have an honest treatment of the Second Amendment. That's just my opinion. But nevertheless, let's set that issue aside. The Fourth Circuit is overall terrible on the Second Amendment, although there are a few judges that will respect it. Now, so what do I think is going on here? Why is a relatively simple arms ban case that you simply apply the in common use test? The government is clearly going to lose this if you're honest about it. Why are we not getting a panel decision? And I think what the answer is goes back to the year of our Lord 2020 in a case called Wise versus, I'm going to hope I get this pronunciation right, Wise versus Circosta, involving a voting rights issue out of North Carolina. Now you're maybe saying like, Mark, what are you talking about? We're not talking about voting rights here. What are you talking about? Well, let me tell you what happened. In this case involving the United States Court of Appeals in Weiss versus Circosta, October 20th, 2020, I'll put a link to it down below. Guess what happened? It turns out that, and I'm going to read you exactly what happened from the dissent in this, that there was an appeal from the district court in a voting rights case out of North Carolina. And a three-judge panel was assigned, and the three-judge panel split 2-1 with 2 judges going to rule in favor of an injunction that would have been in favor of the North Carolina legislature, which I believe is Republican controlled. And the dissent was upset, the dissenting judge was upset because the 2 judges were going to rule for the Republicans in the North Carolina legislature. So what happened was the dissenting judge, before the panel issued its formal decision, once the dissenting judge on that 3-judge panel realized that she or he was going to lose, their view was going to lose, that dissenting judge went running to the rest of the Fourth Circuit Court of Appeals internally and got them to en banc the case before the panel of 3 ever got a chance to issue their formal opinion. So I suspect what may be happening here in Bianchi is that a 2-to-1 decision had been drafted or had been voted on in favor of the Second Amendment. I suspect that the judge that's playing this game, this is my speculation, is Judge Stephanie Thacker, because she was definitely anti-gun, insane in my view in terms of her questions associated with the Second Amendment, as I recall from a year ago, and she seemed absolutely terrible with her questions on the Second Amendment. That was my view. So I have a feeling, and this is my speculation, that Judge Thacker has gone to the rest of the Fourth Circuit and got them to internally en banc the Bianchi case, and now the entire Court of Appeals for the Fourth Circuit is going to issue an anti-gun, anti-Second Amendment ruling. Now, you may say to me, Mark, isn't that crazy? What are you talking about? Can that happen? Well, the answer is yes, because it specifically happened in another sort of politically tinged, politically oriented case, culturally oriented case, whatever you want to say, kind of a hot potato, hot topic case, in this Wise versus Sikorsky case. Specifically, here is what the dissenting judge wrote, and by dissenting judge, the en banc Fourth Circuit Court of Appeals issued this decision really in favor of the Democrats. I won't bore you with the details, but essentially it extended the time that mail-in ballots would be accepted beyond what the legislature thought the law provided. There's a fight about this, and the bottom line is that the majority of the Fourth Circuit Court of Appeals ruled essentially in favor of the Democrats, as I understand it, against the Republican legislature of North Carolina, and that's where the tension occurred. But here's what's very interesting. Take a listen to this dissenting decision, dissenting from the en banc ruling against the Republicans of North Carolina. This is what Judge Paul Niemeyer wrote with the support of other dissenters on that en banc panel. Okay? Judge Niemeyer writes the following: I am pleased to join the dissenting opinion written by the panel majority. Did you hear what I just said? I am pleased to join the dissenting opinion written by the panel majority. This case was originally assigned to a panel. Remember, panel of 3 judges. Was originally assigned to a panel of the 3 judges. But the work of the panel was hastily preempted by an en banc vote. By an en banc vote requested by the panel's dissenter after the panel majority had shared its views, but before those views could be published. Do you hear what I just said? In the Weiss versus Sikorsky case in 2020, the 3-judge panel had decided what they were going to do in this voting rights case. They came out and said in a 2-to-1 decision that they were going to rule essentially for the North Carolina legislature, which I believe, again, is controlled by the Republicans, at least it was at the time. And guess what happened? The dissenting judge asked that the panel not be allowed to issue their decision, but instead en banced it so that the entire en banc, meaning an en banc means the entire Court of Appeals would rule on the case, and that's exactly what happened. And then the entire Fourth Circuit came out and issued an en banc decision against the Republican legislators in North Carolina. But this only occurred after that one dissenting judge realized that he or she was going to lose. And I suspect, and again, I don't want to defame anyone or suggest that I'm absolutely certain of this, I'm not, But I'm speculating that a possible reason why it's taken almost a year for the Bianchi case to come out is perhaps that the three-judge panel is no longer in control of the ship, and that internally, Judge Thacker or perhaps one of the other judges, although I suspect if it's any of them, it will be Judge Thacker. She seemed pretty hostile to the Second Amendment, and I think her record is pretty hostile to the Second Amendment. So my guess, if I was forced to guess, would be it would be her as the dissenting judge on that three-judge panel. Again, I could be totally wrong on all of this. This is total speculation, but it's based on what happened in 2020 with this Weiss versus Circostates case. Now, again, let me continue on with what Judge Paul Niemeyer said after pointing out what happened in this case. He goes on to write, in this Weiss case, quote, "To be sure, an en banc hearing may be requested at any time. But the traditional practice of this court is for the assigned panel," remember a panel is three judges, the en banc is all the judges of a court of appeals. "But the traditional practice of this court is for the assigned panel to hear a case and publish its opinion before the court considers whether to rehear the case en banc. Once in a rare while, the court is elected instead to hear a case en banc before consideration by a panel on the ground that the extraordinary importance of the matter justifies the participation of the entire court. But here, neither course was followed." So here you have Judge Niemeyer saying and concluding, "I dissent from the preemptive en banc action in this case and for the reasons given by the panel majority." See, this is what maybe happened in a Bianchi. I have no other explanation why an easy case like Bianchi would take a year to decide. Even if you're going to rule against the Second Amendment, it shouldn't take this long. Because remember, Heller in 2008 was an arms ban case. So all they have to do is read the Heller decision, and Bruin reaffirmed Heller like literally 80 times. There's literally nothing in Bruin that suggests that Heller is not the law of the land. We've talked about this before. So all this three-judge panel had to do between December 6, 2022, and today is read Heller and write their opinions or their dissents, whatever they wanted to do, and get it out the door. And yet that's not happening. So why is this delay occurring when other Second Amendment cases have been argued and decided in the same time period? Why is Bianchi being held back? And I suspect, my speculation, only time will tell to see if I'm right, but I'm pretty good at this. But I'm not perfect. Anything's possible. It'd be very interesting to see if one day we wake up and that the Fourth Circuit Court of Appeals has just issues an en banc decision against the Second Amendment. And I suspect if they do this, what they're going to try to do is they're going to come up with some excuse to send this back to the district court to drag their feet. Because as I see it, in my opinion, anti-gun courts and anti-gunners across America, the last thing they want to see is any other Second Amendment cases before the U.S. Supreme Court. They make an exception for the Rahimi case because Zaki Rahimi was such an odious character on the record. But other than that, they don't want to see any Second Amendment or gun-related cases before this Supreme Court, because what they really want is the Supreme Court to change with either Justice Alito or Justice Thomas basically leaving the court so they can put on a Joe Biden pick to the Supreme Court and change the balance of power, if you will. That is clearly what's going on here. They are slow-walking all Second Amendment cases, and I suspect Bianchi is now being slow-walked. And the question is, how would it be slow-walked by a panel which appeared to be in a 2-1 favorable to the Second Amendment? The only explanation for it being slow-walked, as I can see it, is that the Court of Appeals for the Fourth Circuit is doing exactly what they did in Wood versus Circosta 2020, which we just discussed. So only time will tell to see if my speculation is right, and we will see. But if nothing else, at least you've connected some dots here about what might be occurring. Maybe I'm totally off, but only time will tell. But I'm starting to think that I might be right on this, so we'll see. All right, folks, hope you learned a little bit something today here at the Four Boxes Diner. If you haven't subscribed, please do so. And don't forget to share and like this video and share it with your friends, of course. And don't forget to follow me on X at Four Boxes Diner, where I provide more Second Amendment related information every day in addition to what I do on this channel. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.